Labadiena, Nacionalinio žmogaus teisių forumo dalyviai ir žiūrovai.
Good afternoon, participants and attendees of our forum, National Forum on Human Rights. My name is Roberta Tracevičiūtė. I am a journalist at 15 Minutes LT, and I am the moderator. This year, in early 2020, the European Court of Human Rights delivered a judgment in the case of Beizaras and Levickas versus Lithuania, in which it not only concluded that the Republic of Lithuania discriminated against the applications on grounds of their sexual orientation, but also criticized the established practice on the courts and law enforcement institutions related to the criteria of threat and systematic nature when investigating hate crime. The aim of this session is to discuss the obstacles that are faced during the pre-trial investigation and the legal proceedings, and what the government institutions can do to improve their response to hate crime. Moreover, answers will be sought how the principles and criticism specified in the ECHR's ruling will change the law enforcement institutions' view and on reaction to hate crime and hate speech. During the discussion, we have 7 panelists, and allow me to present them. Dovilė Murauskienė is a lawyer, lecturer at MRU Law School. Viktor Kundrak, hate crime officer for the OSCE Office for Democratic Institutions and Human Rights. Mr. Aurelijus Gutauskas, chairman of the Criminal Division of Supreme Court of Lithuania. Judge Jurga Zieniūtė is prosecutor at the Prosecutor General's Office of the Republic of Lithuania, and Pijus Beizaras is LGBT community representative, human rights activist. And police will be represented by Aušra Sadauskienė and Giedrius Kanapys. Before starting the discussion, I would like to introduce the cause of it and to establish some house rules. Since we have some guests abroad, this discussion will be interpreted into English and from English into Lithuanian. If you need interpretation services, you see the icon, which is called interpretation, and you're welcome to choose the needed language. The discussion is also interpreted into and from sign language. It is being broadcasted directly, but later on, the recording will be found in the National Forum on Human Rights forum website. If you happen to have any observations or questions, you're welcome to write them in the question and answer or chat area. I will see the questions and I will be able to read the questions to the panelists. At the end of the discussion, the viewers will be able to participate in a competition and win a prize. You will have to answer one question that will be formulated at the end of the discussion, and the first 3 respondents will be awarded with prize established by the National Forum on Human Rights. Firstly, we will start from Ms. Murauskienė's report on the called Strasbourg Court ruling that has slowed down Lithuanian court practice. Thank you very much for this invitation. I have awaited this court ruling for a long time, and it's never boring to talk about it because we see the real and tangible results of this court ruling. Understanding the time constraints, I will present this court ruling of January the 16th, Beizaras and Levickas against Lithuania, which was adopted in 2020 against homophobic speech. I will speak about the case law before this ruling and after, and how the case law should change in the future. The attitude towards hate speech before was rather complicated, but I will dedicate a few minutes of my time for that as well. The hate crime and hate inciting speech, these two things are a little bit different from each other. They are different in terms of risks, danger, and they are different in practical terms when the courts have to establish whether the criminal offense was made or not. If the crime was made due to hate towards a certain group, then this criminal offense is being proved in a simple manner, and it's easier to adopt the decision. However, hate speech, it poses some problems in practice, and it is worth saying that criminalization of hate speech is indicated in one article of the Criminal Code, and this is Article 170. The hate speech is described as taunting, as incitement to hatred, and trying to, it's when it is directed against a specific group. And these attributes are indicated. This is age, sex, disability, race, language, religion, and other things. These features are indicated with a purpose. They encompass social context and historical context. And it is based on the previous cases of hate speech. It is also considered how discriminated, what pressure the specific group feels at the moment. And the form of taunting, taunting and inciting hatred. These problems in case law that were specified by the European Court of Human Rights in its court ruling came from the fact that hate speech is of a formal nature. The consequences allowing to differentiate when it is considered a crime and when it is not considered a crime are not there. When there is, in this case, there is a challenge for the court to decide whether certain actions are dangerous or not. And in this case, two values are important, and this is the right of expression and a right to equal treatment and a right to non-discrimination. The self-expression, the right to self-expression is the same freedom as the freedom to equality. And these problems are being addressed in the following case. Our case law is being formed by ultima ratio doctrine, which means that the criminal responsibility has to be imposed only for those criminal offenses that are really dangerous and cause dangerous consequences. Ultima ratio doctrine in the Lithuanian case law has come from old age, and it was first mentioned in the 17th century, which was said that the last shot of a king will be ultima ratio. And this means that the last word of the court is the one to be considered. Therefore, this ultima ratio principle is useful in deciding which actions and which speech of hate is dangerous in that sense that it should be considered as criminal offense and the perpetrator should be prosecuted. The hate speech was being criminalized, and by January 2020, the courts had certain criteria by which it used to decide whether a certain comment met this criterion of being dangerous. Here we have three groups of circumstances. The first one is the way of information dissemination. And there is a rule that the message spread online is more dangerous than other message because it reaches more readers, it can be kept there for a longer time. And this rule has been mentioned by the European Court of Human Rights in its ruling Beizaras against Lithuania. The second criterion, which poses most of the problems, is system consistency. And this consistency is the criterion, which basically means that if there was one comment written online, it doesn't mean that this person intentionally spread hate speech and that his or her actions are that dangerous, so as the criminal responsibility should be, so that the person should be prosecuted. And I will come back to this circumstance. And the third group of circumstances, it was taken over from the European Court of Human Rights, and it is called context. It means that each message should be assessed not only by its content, but also having in mind the context in which it was expressed. This means that if the situation in that particular group is tense, then this comment is regarded more dangerous. For example, if homophobia is a very dangerous phenomenon in a certain state, then it means that in that state, homophobic statements are regarded more serious than in other states. And this criterion is also very important. It allows assessing the level of danger of hate speech. It has also been mentioned in the case of Beizaras and Levickas against Lithuania. And in January 2020, the courts had clear guidance, but it happened that the decision was taken, and this decision was rather strict. There were 3 articles of conventions violated by Lithuania. And now I am going to mention some circumstances. And basically, this court ruling is about a kiss. 2 boys downloaded a photograph of their kiss, and then the situation was commented, and 32 comments were clearly interrelated to incitement to hatred, urge to kill them, Therefore, the non-NGO applied to court and asked to start the pre-trial investigation. However, the prosecutors refused to do that, having in mind the consistency criterion, and therefore the first ruling remained enforced. The NGO challenged this decision, and it went to other courts, and these courts, they expressed their opinion even in a larger sense. They expressed their arguments and provided the argument. Besides the argument of consistency, they also stated that the men who publicized this photograph, they didn't realize that the reactions will be so dramatic, and therefore pre-trial investigation was not started, and finally it reached the Court of European Human Rights Court. 3 articles were violated, Article 8 and Article 14. This is a right to private life, respect for private life, and the court repeated its earlier case law, and they said that private life is a very important part of life, and when there is a danger to specific aspects of one's life, then the penal measures have to be introduced, and the state, when the state refused to start the process in the court, they violated another article which prohibits discrimination. Article 13 of the Convention requires to ensure effective measures of redress, and the victims had appropriate reaction. However, the courts violated Article 13 by refusing to start the case. And there were some arguments presented. Some of them were related to content, some of them were related to the process, and one of the most important aspects were the following: that the hate speech should be interrelated to the content of the speech rather than the formal aspect of it. And the number of comments could be the circumstance that demonstrates the higher level of danger or the penal responsibility. But this is not criminal offense as indicated in the Criminal Code, Article 170. And since another argument was the following: since there was an urge to be violent, then the criterion of consistency shouldn't be applied, because it is clear that this criminal offense poses danger. And the criminal responsibility has to be applied, but sometimes it is enough to see that there was contempt and incitement of violence against a certain group of people, and the government has to ensure the effective use of the convention. And in this case, towards the people who belong to the sexual minority. The procedural issues were also important, as explained in the court ruling. The court analyzed certain procedural issues, and it was noted that in Lithuania, the pre-trial investigations are quite often not finalized due to as far as hate speech, and it happens that people who addressed to court or who spread this information in the environment, they will be more reluctant to address the court or police for the second time, because when it is being refused to continue with the court proceedings, it's regarded as the second victimization, when the victim was not believed and when the hurt was not considered sufficient enough to be processed in court. And Lithuanian law enforcement authorities accept certain crimes and accept certain situations, and quite often the specialists are involved and they assess the content of the speech. Sometimes the journalists have to explain what this content meant. And in 2016, there was the court ruling of the Supreme Court of Lithuania, in which the Supreme Court used a few dictionaries in order to draw to a conclusion that certain name calling is not acceptable. Basically, the court says, be braver when assessing the content, because really nobody needs to address, for example, journalists in order to know that the word proverb is demeaning. The role of the NGOs was highlighted in the court ruling. There was a petition made, and the court said that it is acceptable that NGOs address to court. This is normally the purpose of NGOs, and nobody objects the NGOs addressing to courts and representing the victims. The court appealed to the vulnerability of victims. Lithuania has implemented the directive of the European Council on Victims. When the vulnerable victims are considered to be more vulnerable, and this means that the state has to ensure additional guarantees, and the participation of the NGO in the process was considered to be that support provided to the victim. And this has to be taken into consideration. These were the main conclusions, and now I would like to speak a bit about one other case, Lilian against Iceland, which was adopted after the court ruling of Beizaras and Levickas against Lithuania, which was basically the continuation of the ideas in the court ruling Beizaras and Levickas against Lithuania. In Iceland, the petition was submitted by the person who was sentenced for homophobic speech. And in this speech, he indicated only one comment. He didn't urge to kill or to injure. He just expressed his disapproval for the sexual education at school. And the court, in his ruling, stated that the complaint was acceptable. And this was related to the 210 article of the convention, and the court stated that the right of self-expression does not include the right to hate speech, because if your speech is considered to be hate speech, then your freedom to the right of expression ends there. The Court of the Human Rights made a step which limited the discretion of the state in deciding which actions should be considered the actions of hate and which aren't. The formal and artificial features cannot be considered as criteria for refusing to defend the people. Thank you very much for your attention. I will be looking forward to your questions and will participate in the discussion.
In your discussion. Thank you, Madam Murauskienė, for the presentation. Our next speaker will take an even wider approach, and this will be Viktor Kundrak from the Hate Crime Officer for the OSCE Office for Democratic Institutions and Human Rights. So, Mr. Kundrak, the floor is yours.
Yeah, hello, dear colleagues. Sorry for this technical issue. It always happens. First of all, let me thank the organizers for inviting OSCE, ODIHR, and myself to speak at this fantastic and inspiring event. All the presentations were I've been eagerly listening and watching. My name is Viktor Kundrak, and I work at ODIHR as a hate crimes officer, similarly as my colleague Aurelijus, who's spoken in the previous panel. As you already probably know, ODIHR stands for Office for Democratic Institutions and Human Rights, and I will try not to use any more abbreviations today. Our mandate is to support states in meeting their human dimension commitments. My colleague Aleš has elaborated on what such support can look like if the state authorities approach us with a request for assistance. Now let's go to the point and address the topic of my presentation, the issue of verbal hate crimes. We're addressing the area in the particular context of a Lithuanian case adjudicated by the European Court of Human Rights concerning acts which for some are hate speech and for others verbal hate crimes. One may say, does it matter whether we call it an act of a hate crime or hate speech if it's already criminalized by national legislation? My response is yes, it does. The Beizaras and Levickas case represents a great example how confusions around what is hate speech, what is a protected speech, and what constitutes a hate crime have a direct impact on the case, on whether police takes the case further, what would be the prosecutor's stake, and whether and how a case would be adjudicated. And the confusions exist among experts, international and national, and among different regional and universal IGOs. While there is intergovernmental organizations, obviously, while there is no universally adopted definition of hate speech, we may find several of them intersecting and overlapping, each of them missing or adding elements vis-a-vis another. OSCE, the organization I represent, on the other hand, as mentioned by my colleague earlier, provides an internationally agreed open definition of hate crime, which is then sometimes, however, misinterpreted on the national level. For the OSCE participating states, which is 57 states, including North America, Europe, and Central Asia, Hate crime is a criminal offense committed with a biased motivation. Now, does this also comprise hate speech offenses committed with a particular biased motivation? Not all, but some do. Written or verbal threats, as well as incitement to violence, constitute so-called verbally committed hate crimes. And one needs to understand the context and consider the OSCE, that OSCE encompasses a wide range of states, not all of which agree with criminalization of, say, incitement to hatred. And there is a good reason for it. If one looks into the European Court of Human Rights case law, one notices a clear difference between two branches of case law. First, there's been a strong branch on the positive obligation to conduct an effective investigation of hate crimes under Article 2 and 3 in combination with Article 14 of the Convention. These are cases of physical violence affecting one's physical integrity. The case is Nachova versus Bulgaria, Shkoryanets versus Croatia, Balash versus Hungary, Identuba, and others versus Georgia, and I could name many more, represents those. These obligations, the obligation on effective investigation of hate crime, means literally to unmask any potential bias, be it racist, homophobic, anti-religious, or similar. And how? With the use of bias indicators. And if someone is interested more or would like to explore more on that, I would welcome, I would encourage everyone to visit ODIHR's work on that. So we have in our publications. Bias indicators is a tool to recognize hate crimes for every police officer that might encounter those. Not only police officer, of course, prosecutors and judges too. The court has further expanded this obligation on concerning physical violence to the area of mental integrity, where physical integrity is not at stake. And it has done so under Article 8 of the Convention in the area of private life. These cases concerned verbal threats. And the first one was RB versus Hungary, followed by Kirali and Demeter, Kirali and Demeter versus Hungary, Alkovic versus Montenegro, and others. In all of these cases, there were the victims who complained before the European Court of Human Rights that the state authorities had failed to comply with the obligation to investigate effectively their case. Now, the area of hate speech, and in particular, the acts of incitement to hatred or discrimination, other forms of collective defamation or denial, genocide, have been submitted to the court by those who had thought that their freedom of expression was violated when they used discriminatory, racist, or homophobic speech. In these cases, the court was called upon to assess whether the parameters of the restriction to freedom of expression were in compliance with the European Convention. There is 1% out of 100% of all these cases, of all these hate speech cases, in which it were the victims who brought the case before the court, and is the case Beizaras and Levickas versus Lithuania. This is the first occasion where the court had to answer whether the victim of a hateful online comment, or a big number of hateful online comments on social media, have the right for their case to be effectively prosecuted. For some, this is a hate speech case. They were verbal utterances, correct? For others, like myself, they were, or at least some of them, hate crimes. Why? Because they constituted direct threat for the two applicants, as well as incitement to violence. These are the reasons why I believe the case made it to the European Court of Human Rights adjudication. There was tangible harm that the two applicants suffered, and the seriousness of the comments surpassed the threshold of mere incitement to hatred. And this is important. While not all forms of hate speech must be criminalized, I think all would agree. Take simple insult on the street. But all hate crimes, on the other hand, should be criminalized. without a single exception. No balancing exercise is at stake to weigh protection from discrimination against freedom of expression. Thus, what I see as the main failure of the practitioners, including those who were in charge of the Beizaras and Levickas case, the comments at stake from my perspective, but also based on a well-established court's case law, deserve no protection under Article 10 of the Convention. What this means is that the whole array of commitments should have been enacted. I mean, now states' commitments vis-a-vis OSCE ODIHR, their obligations stemming from the European Convention and others. From correct application of the law through effective investigation to the provision from the outset of the support and protection to the victims. None of this happened. Why? The court has addressed this, and I'm not going to further elaborate on that. And it's being addressed by my colleague in the preceding speech. There's, among other, been also different treatment of cases with a bias based on sexual orientation vis-a-vis other protected grounds, such as motivation, such as anti-Semitic. What I would find very useful is, at least on a practical level, to minimize using the terms of hate crime and hate speech and focus more on the individual harm suffered by concrete victims. This is where the focus is needed most importantly, in my opinion. Recognizing that also verbal comments can cause some form of individual harm is a starting point. As my colleague Aleš Hanek also pointed out, individual needs assessment of the victim's needs is a second step, which should then lead to actual provision of the necessary support. Our dear colleagues, Pijus Beizaras and Levickas, and hundreds more received none of that. Fortunately, the applicants in the Discuss case benefited of the support of the LGL Association, who did at least an excellent litigation work. I'm not sure to what extent could the applicants benefit from all other forms of support, such as psychological. To conclude, I'd just like to say a few points. The online world has become, and I think at least since this February, for most of us, an inherent part of our private life. We live our emails, our social media, our Zoom calls. The difference between an encounter in street and chat online is not as big as we may have perceived it years ago. And while experts, such as all of us here sitting in the panels, have been trying hard to find solutions, including addressing difficult philosophical questions, etc. How to reconcile freedom of expression with other protected interests and rights, whether there is a human right to internet, right to access to information. The practitioners, including police officers and prosecutors and judges, have been confused, have no guidance, have little guidance on how to address these phenomena, and this has a direct impact on victims' lives on a daily basis. To end very finally on a positive note, and as also it's been mentioned by Aleš and the European Court of Human Rights, Lithuania has gone a long way to addressing hate crime, since the facts of the case, through training police, awareness raising, addressing the recording and data. And one has to be fair and recognize the time lapse since the acts of the case. One also has to be aware of the progressive nature of the European Court of Human Rights case law and of the international human rights framework, since the positive obligation to investigate verbal hate crimes was addressed explicitly in 2016 only, for the first time, with the RB versus Hungary judgment. Before that, only acts of physical harm constituted, let's say, the base offense to which, if committed with a bias, would enact the positive obligation to effective investigation of hate crimes. But more needs to be done, I'd say, and as Alex said, ODIHR is here to support both the state and civil society, if need be, in making hate crimes, including verbal hate crimes, untolerated. And I'm here also today to answer any potential questions if you have those. Thank you very much.
Thank you, Mr. Kundrak. We have half an hour. Thank you, Mr. Kundrak. We have half an hour for our debate. I believe we will be able to address various questions. First, I'd like to give the floor to Mr. Beizaras, one of the applicants in the case of Beizaras and Levickas versus Lithuania. So my question to you is, what is your personal experience? What were the most surprising things when it comes to our law enforcement institution? Well, you had to wait for the judgment of the European Court of Human Rights for 5 years. So can you comment on that? Good afternoon, ladies and gentlemen. Thank you for the opportunity to be here and to talk on this topic. It is very important for me. And I'm grateful to Viktor Kundrak. I am grateful to Dovilė for their presentation and for the way they described all those situations. I have a similar approach. It was very painful for me to receive all those rulings from the state not to launch the investigation. Well, I was not happy to see that the Lithuanian court said that those comments had no continuity. Still, we believed that the offense was committed. It had certain negative implications on us, both on my personal life, on the personal life of both me and Mangirdas. So I was very sad about those rulings, and I was very sad about the fact that I had to take so much effort to get to the European Human Court and to have the ruling of the European Court. I hope that this ruling will have some significant
Lietuvos teisinėje sistemoje, kad bus svari ta pergalė.
Implications in the Lithuanian legal system, and that it will help formulate new case law, and that no one else will ever have to take the path we had to, and that the decisions taken by courts will be good for us all. So that would be all. Thank you. I have one more question to you. How did you take the courage to take the path to bring the court with to bring the case with the European Court of Human Rights? Well, today we talked a lot about the latent nature of hate crimes. And in many cases, victims of hate crimes don't even report such offenses to the police. For example, Lithuanian law enforcement officials called those photographs as an example of eccentric behavior that was intended to raise negative approaches within the people who had different attitudes. Some other blamed you for violating family values.
Tai visų pirma, man diskutuojant iš tikrųjų yra tekę dažnai girdėti, kad Lietuvoje labai mažai yra.
Too often I heard that the number of hate crimes in Lithuania is very low, but I believe that these figures are distorted. They are not correct. People do not report hate crimes because they see the inactivity of law enforcement institutions. They see the negative attitudes of law enforcement officials. They have a fear to report because they have already seen certain examples from previous cases where one or another offender was not convicted for the hate crimes or for the hate speech. So people are simply afraid and they do not want to waste their time.
Aš šiek tiek minčių esu užsirašęs apie tai. Taip, tai viena dar labai didelė problema yra tikriausiai ta.
There is yet another problem. The decisions that were taken by Lithuanian courts were guided by personal prejudices rather than legal arguments. Well, you mentioned eccentric behavior and that we were ourselves guilty for posting those pictures. I think that law enforcement officers should not be using such arguments because these arguments are of personal nature, and such arguments, being biased, should not be included in court rulings. Decisions of the court should be based on legal provisions. Thank you, Mr. Beizaras. Now, I'd like to ask our law enforcement representatives how they treat hate crimes, what they think a hate crime is and what is not. A previous speaker, Arūnas Valinskas, Speaker of the Lithuanian Parliament, said that, I will quote, Tomaszewskis is a Colorado beetle and he is against the state. Such people should be shot, one every year. So Vilnius County Prosecutor's Office terminated the proceedings because it ruled that the comment constituted no elements of criminal act. So what else, whom else can we tell that we can shoot without any implications, legal implications on us? So what is the view of the police? In the specific case that you have mentioned, the decision of the court is not effective yet, so I'm not going to comment on it. But how does the law enforcement officials treat hate speeches? What they think is and what is not examples of hate speech? Well, in principle, hate crimes are the crimes that are defined in articles, in separate articles of the Criminal Code of Lithuania, and that are based on certain prejudices or bias. In the previous discussion, it was mentioned that police officers sometimes fail to identify hate crimes. Don't you think this is a problem? Well, yes, I think it is a problem, but we have various training and education programs in place. We are trying to teach our officials how to identify hate crimes, how to identify the motives behind one or another comment. Thank you. Now, I'd like to give the floor to Jurga Zieniūtė. I have the same question. How do you identify, how do you treat what a hate speech is and what is not? Good afternoon. First and foremost, let me thank you for a very interesting discussion and to congratulate all the panelists and participants on this very interesting conference. The debate has a very interesting format. We have many well-known experts dealing with the area of hate crimes. So when it comes to defining and interpreting what hate crime or hate speech is, I'd like to note that, in fact, the criminal code does not contain the definition of hate speech. Certain provisions do define that if the person was murdered due to on the grounds of, let's say, some characteristics, this crime may be defined as the crime which was conducted on the basis of hate. We try to identify what could be considered as a hate speech and what hate language might be. There are several methodological recommendations. Some of the provisions of the criminal code have been taken, and I believe that hate crimes cover the offenses that are included in Article 170 of the Criminal Code. These include incitement against any national, racial, ethnic, religious, or other groups of persons, or incitement and hate speech against publicly recognized phenomenon. I was very grateful to hear the opinion of Viktor Kundrak from the OSCE. When it comes to the case of Beizaras and Levickas versus Lithuania, police, we believe that that was a verbal threat to kill one of the applicants. So if we looked very narrowly only at paragraphs 1 and 2 of Article 170 of Criminal Code, we would not see the clear picture. So it seems that public approach and the approach of law enforcement officers is being developed now. We have had a lesson already. I cannot promise that we will not make any more mistakes. I would not be willing to speak about the case that you have just referred to, because as the police officer has said, the decision, the decision of that court is not effective yet. But, well, the experience and the recommendations from the European Court of Human Rights is very important. Now, I have a question to Giedrius Kanapinis. Good afternoon. First and foremost, let me congratulate everyone on the Human Rights Day, and I'm grateful for the invitation to participate here. When it comes to the definition of hate crimes, it should be noted that both in the European Union and in Lithuania, the major threat that is related to hate is disseminated towards people of different sexual orientation. It seems that this intolerance of people is related to different sexual orientation. Even in our society, we see that our population do not believe that they can defend their rights through legal means. So if our ordinary population does not trust our legal law enforcement institutions, what could be said about the most vulnerable groups? Therefore, those offenders have an incentive to further commit offenses of the kind. And the hate that is justified sometimes gains popularity among politicians in the social media, and certain comments are already accepted as a norm. So I'd like to draw your attention to the fact that certain people feel very vulnerable, they feel abused, and they feel that their dignity and honor are being undermined. That's why in our society we have a prevailing opinion that it is the people themselves that provoke the wider audience. But I am convinced that despite the fact that our criminal code is in line with various provisions of the EU documents and international human rights organizations documents, it is still insufficient when it comes to persecution of hate crimes, physical attacks. We
jeigu tai susiję su būtent neapykantos skatinimu, taip. Galiausiai mes
we know that incitement to hate is an aggravating circumstance, and the person might be convicted to up to 3 years in prison for disseminating hatred. Well, we do have the Administrative Offences Code, and this code contains a separate chapter that covers administrative offences related to the inviolability of persons' private life, but it does not embrace the hate crimes in the sense that we are referring to. In other words, our laws are not systematic. So if a person commits an offense related to hate, but if this offense is not very dangerous, just like in the previously mentioned case when the proceedings were terminated and the offender remains unpunished, so This is not good. And we don't have the possibility to apply administrative liability for hate crimes, which means that the Administrative Offences Code should include a separate chapter on the liability for hate crimes. And finally, I would not agree that termination of pretrial investigation does not involve any implications on the offender. The proceedings themselves inflict certain implications on the offender, but, well, the offender himself is made to think his actions over. I welcome the address and the determination by Pijus Beizaras. I congratulate them on their victory, on what they have achieved in the European Court of Human Rights. So Lithuanian courts will now have certain guidelines as to how to act in similar cases. Viktor Kundrak has also mentioned certain elements related to private life that we reveal in social media, Twitter, or various apps. So it sometimes seems that we make our private life public ourselves. That is why there are a number of commentators who are eager, especially the anonymous ones, anonymous commentators, so who are eager to incite hatred and to spread those hate speech comments. And I think it would require huge resources to prosecute each and every offender. Well, if I have a possibility, I will speak later on.
There is one other question. Who has to assess the social context in hate speech cases? Ms. Murauskienė, could you please answer this question?
Taip, be abejo, tą klausimą irgi buvau mačius
pagalvojau. I've noted this question, which is very interesting. This has to be done by the court. And when the court receives the case regarding a specific criminal offense, the assessment of gravity has to be made, which is interrelated to context. And then it's up to the court to assess the context. It depends on the public prosecutor's role. And for example, in Beizaras and Levickas against Lithuania, the court assessed the context based on the data submitted by NGOs as well as their empirical studies, and took into consideration the tension in this area. And the same happened in the case that I have mentioned against Iceland. The context in Iceland has less pressure. However, it has sufficient pressure for the situation to have important gravity. And the final court ruling has to indicate this, and only the court has the right and obligation to assess the context in specific situation. Thank you, Ms. Murauskienė. Now I would like to address Mr. Beizaras. You have said that you enjoyed the victory. However, the decision is not into effect yet. And in your Facebook, you share the similar stories of other people. They do not have the efficient legal protection in Lithuania. Yes, indeed, this is a very good question. We observe very similar trends in Lithuania. Quite recently, I reported a hate speech against me to police. And I was really disappointed because I have received exactly the same response, that the pre-trial investigation will not be launched. However, it is hopeful that when I addressed the prosecutor's office, when I challenged this decision, the prosecutor's office decided to start the pre-trial investigation. So I see the light in the tunnel. However, it is disappointing that it is not possible or hard to impossible to address these problems at the first instance. Well, I think the change is taking place and it will take time. It will not happen in one night. But our victory with the Court of the Human Rights should have a significant contribution. I would like to ask you, what changes seem to you the most important? How would you regard this thing if you were just an outsider? Well, I think that hate speech, hate crimes have to be regarded seriously, because up until now, they were not considered to be serious enough. And Mr. Gutauskas has mentioned that a lot of resources are needed in order to find all of these people, but police has the means. And I don't think that this could be used as an argument for not failing to start the investigation. And I would like things like that to be regarded more seriously. So far, we need it and we lack it. Thank you, Mr. Beizaras. And now I have the last question for all the panelists. What do you think about the court ruling? How it could influence the attitude and reaction towards hate speech and hate crimes by the Lithuanian courts? What could the ideal situation look like? How could the courts regard the hate crimes in the future? And I will give the floor to Mr. Kundrotas.
Okay, thank you, Roberta, for the question.
Kundrak.
Yes, thank you for the question. To start with, I'd like, if I may, just very quickly comment on two points. First of all, is our colleague, Mr. Gutauskas, made the difference between the online world, the issue of private sector that we actually publish online, as opposed to, I would guess, a living room, right? A physical living room. So like this is a phenomena that we're observing in the past decades. Situation has enormously changed. And there has been a very interesting constitutional court's decision in the Czech Republic concerning a very similar case, actually, to Beizaras and Levickas. It concerned them, and maybe it will be addressed by our Czech speaker in another panel. But it was a case of a Roma singer that went public with some very strong opinion against, let's say, a neo-Nazi band. and got some 4,000 hateful comments on his wall. The criminal justice system, police, prosecutors dealt with it as also under a similar provision as in the Beizaras and Levickas case, incitement to hatred, or sort of a hate speech, classical hate speech provision. And because of that, they didn't recognize the existence of a victim, because these offenses do not target, in terms of criminal law jargon, do not target physical well-being of individuals, but sort of well-being of a society, right? And they did not recognize the existence and status of a victim. Therefore, again, the victim was excluded of all the support necessary. And the Constitutional Court said one important thing, that nowadays, hateful comments on somebody's Facebook or other social media wall are comparable to graffiti on the wall of Jewish shops during the Kristallnacht, during the events of '39. The private sector we're exposing to the public has become a new normal. What is the real difference between a graffiti on my house or on my window and hateful comments on my own Facebook wall? Who has the right to slander me with a racist language? And I won't speak about the nature of internet and how these can be replicated, and these utterances can be replicated and stay forever on the internet. While you can clean the graffiti, you cannot clean all these comments very often. So that's just one point. Second point on context versus content. If one looks at the European Court of Human Rights case law, you see that once there is a content that is clearly unacceptable, protection of freedom of expression doesn't even come to play. And these comments, at least some of them that were dealt with in the Beizaras and Levickas case, they were unprotected speech. And these include incitement to brutal violence and threats, right? These are not protected speech. And in terms of, and to finally answer your question very quickly, I think now Lithuania has to execute a judgment, provide to the Committee of Ministers of the Council of Europe a report, an action plan, what it will do. And I would anticipate that, you know, the action points should be on different levels: police, prosecution, judiciary, not simply disseminating the judgment and raising awareness, but concrete actions in terms of what my colleague identified, improving the recording mechanisms, but also supporting victims and their communities, building trust so that they, at the end of the day, report. Because to recall, and this has been mentioned on many occasions, 90% of all hate crimes are never reported to the state authorities. So there's a lot of work to be done on a daily basis at different levels when it comes to you have legislation. Lithuania has legislation, so you need to improve its application and improve understanding of hate crime versus hate speech, what is a protected speech, what is an unprotected speech, and most importantly, recognize that there's harm caused and that there are victims who are subjected to hate crimes on a daily basis, even when there's no existing data on that.
Ačiū. Ačiū labai, ponia Kundrakai. Taip, judėkim, ponia Kanapienė, jūs, jeigu trumpai.
Thank you, Mr. Kundrat. Would Mr. Kanapienis like to intervene? Very briefly, could you please answer the same question? Well, I think that on the broad sense, the public point of view is very serious. The hate speech and hate crimes are criminalized, and there is criminal liability foreseen for these crimes, and this demonstrates their serious attitude towards them. But as it has been stated by the Court of Human Rights, and as it has been expressed in today's discussions, the case law was different It needed more social context and consistency. Therefore, I hope that the ruling in Beizaras and Levickas case will mark the new beginning in the new case law. It will take some time, but we can already see the results even now. During the last 11 months, there were more criminal offenses registered as compared to the same time last year. So we already on good track. We see some positive shifts in fighting against hate speech and hate crimes. Thank you. And Ms. Zieniūtė, in implementing the ruling of the Court of Human Rights, certain measures are implemented. Speaking of individual measures, I think that the pre-trial investigation has been started and is being performed. I will have in mind the prosecutor's office, what actions have been taken and what is being done at the moment. I think that we started working on it even before the court ruling was issued. We started addressing these crimes and taking into consideration different aspects. As for the implementation of this court ruling, we have really studied it thoroughly. We have invited the specialists, the court representatives that partake in this case, as well as higher prosecutors. We had a meeting. We have heard the essence of this case. We know what were the most painful aspects, and this court ruling has been sent out to everyone, and the prosecutors have been informed about it. We had a few meetings on this. Police officers were also actively participating in the meetings. We have taken other measures as well. Some prosecutors general have checked through similar cases that they had before, and indeed certain the decisions were taken to suspend the case. Vilnius prosecutors are very actively taking part in the process, and the prosecutor's office has initiated the amendments in collecting statistical data so that it becomes easier to collect similar data. And the amendment incorporates things like what aspects could signalize the hate crime or the hate speech. I would like to highlight and to draw your attention to communication aspect. The prosecutors have to engage in communication with NGOs and victims. The authorities, in this case, the authorities discriminated against the applicants, and this experience is the most painful. These are the main aspects. Other than that, it is training, awareness raising. The reports of the international organizations such as OSCE, ECHR, CERDO, the United Nations Committee on elimination of racial discrimination. Well, thank you very much. Unfortunately, we don't have enough time. Mr. Gutauskas, could you please focus on this question? Thank you. I would like to stress a few issues. The prevention of hate crimes is not only quality investigation. It includes education of young people, awareness raising. I think that each person has to understand, has to know how to understand the concept of hate crime. We need to change the attitude of society. The support to the perpetrators was more evident than support of the victims. Basically, the victims were victimized. And some time ago, we didn't know how to investigate similar crimes. I hope that now, after this court ruling and the criteria that have been formulated, we will be able to work better. We need to have more serious attention to the homophobic crimes, and hopefully we'll be able to regard these crimes with more seriousness. And I hope that the perpetrators will not avoid criminal liability. I would like to address the other panelists. Ms. Murauskienė. I would like to demonstrate with my personal example that the situation has been changing. Some time ago, I had training for prosecutors, and these prosecutors were as if saying that we don't have crimes like this. And then when I go back to the same town after 6 months later, they say that they had applied the articles, and they were very happy at the success rate. And I think that this is an excellent sign that education produces results. We just have to persevere. Thank you, Ms. Murauskienė. I would like to thank all the panelists and participants. As I have mentioned at the beginning, there will be question and answers competition. The question is, what were the two applicants that won the case in the Court of the Human Rights in Strasbourg? And those who are the first to answer this question correctly will be awarded. Thank you once again for the discussion, for viewing this discussion, and I wish you interesting day. You are welcome to follow the broadcasting at the forum website. You will find the recordings